My name is Robert Califf. I am the FDA's Commissioner of Food and Drugs. In 2000, FDA approved Mifepristone tablets under the brand name Mifeprex for the termination of pregnancies up to 7 weeks, with several restrictions. In 2016 and 2021, FDA relaxed some of these restrictions.
Due to our sincerely held pro-life beliefs, several individual doctors and 4 pro-life medical associations, including the Alliance for Hippocratic Medicine, AHM, are filing suit under the Administrative Procedure Act, seeking to require the FDA to rescind its approval of Mifepristone or at least rescind the 2016 and 2021 loosening of restrictions.
What? You don't have standing to bring this suit to court because you haven't suffered any injuries. You are free to refrain from prescribing or using Mifepristone. FDA is not making you do anything that violates your beliefs.
I'll be the judge of that. The question we will rule on today is whether the pro-life doctors and organizations have standing in this case. And our answer is no.
I concur.
What? How did you make that decision?
Article 3 of the Constitution confines the jurisdiction of federal courts to cases and controversies. This means that plaintiffs must have a personal stake in a dispute in order to bring a case to court. To establish this standing to sue, a plaintiff must demonstrate, 1. That they have suffered or likely will suffer an injury in fact, 2. That the injury likely was caused or will be caused by the defendant, and 3. That the injury likely would be redressed or remedied by the requested judicial relief. The key questions in most standing disputes are injury in fact and causation. First, injury in fact. This must be a real, concrete injury that affects the plaintiff in a personal, individual way. Plaintiffs who only have general legal, moral, ideological, or policy objections to particular government actions, such as the FDA's loosening of Mifepristone restrictions, have not demonstrated injuries in fact. Second, causation. To establish causation, the plaintiff must show that the government action has caused or likely will cause injury in fact to the plaintiff. When a plaintiff challenges the government's regulation or lack of regulation of someone else, as in this case, standing is difficult to establish. What injury could the government's regulation cause to the doctors or the medical associations? FDA is requiring them neither to prescribe Mifepristone, nor to use Mifepristone, nor to do or refrain from doing anything at all.
Wait, I can prove that the government's regulations are likely to injure me. My first theory is that FDA's relaxed regulation of Mifepristone may cause conscience injuries to doctors. Because the drug is less regulated, more pregnant women will suffer complications from it and need emergency abortions as a result. Therefore, I may be required to perform abortions or provide other abortion-related treatment against my conscience.
No, there are federal conscience laws that protect doctors from being required to provide treatments that violate their conscience.
Well, I have another theory. Doctors may also suffer monetary injuries as a result of FDA's decreased regulation, because time and resources will be diverted from other patients to treat Mifepristone complications, and liability suits and insurance costs may increase.
No, doctors are not permitted to challenge the government's loosening of public safety requirements because they may have to treat more patients as a result. Otherwise, a pediatrician would have standing to challenge a local school district starting a middle school football league, because she might need to spend more time treating concussions. Or a surgeon would have standing to sue the government for repealing gun restrictions because he might have to operate on more gunshot victims. This would be an unprecedented, limitless approach allowing doctors to challenge almost any policy affecting public health.
Well, I have another theory. The medical associations in this case have organizational standing, because FDA has forced them to spend considerable time, energy, and resources advocating against Mifepristone.
That would mean that every organization in the country would have standing to challenge almost every federal policy, as long as they spend a single dollar advocating against that policy.
Well, if we don't have standing, then no one may.
First of all, I'm not convinced that that's true. And even if it were, that is not a valid reason to find standing according to this court's precedents.
I concur. I write separately to highlight the medical associations' claim that they have associational standing to sue for their members' injuries, which is also incorrect. I do not believe there is any constitutional or historical basis for this form of standing, and I encourage the court to explain how the Constitution permits associational standing in an appropriate case.
Well, regardless of that tangent, the doctors and medical associations in this case have no standing. The judgment of the court below is reversed, and the case is remanded for further proceedings consistent with this opinion.
You rule, Supreme Court.
You suck, Supreme Court.